Nifemi Oguntoye. Tonight, one of the most consequential constitutional controversies of Nigeria's Fourth Republic has been decisively settled, well, at least for now. For months, the question has lingered at the heart of our democracy: how far can a president go under a state of emergency? Can the president merely deploy security forces, or can he go further, suspend elected officials and take over the reins of a state government? Today, the Supreme Court has spoken. In a 6-1 split decision, the Apex Court upheld the powers of the president under Section 305 of the 1999 Constitution, affirming that where law and order threatens to collapse, Mr. President can deploy what the court described as extraordinary measures, including the temporary suspension of elected officials, provided such actions are for a limited duration. Justice Mohammed Idris delivered the lead judgment, and he held that the Constitution doesn't define or limit the nature of those extraordinary measures, effectively vesting the president with the discretion in emergency situations. But the ruling was not completely unanimous. Justice Obande Ogbonya, in a strong dissent, agreed that the president may declare a state of emergency, but warned that such power cannot extend to suspending governors, deputy governors, or even state legislatures, arguing that doing so undermines democratic mandates. Even more intriguing is how the case got here. The suit was filed by 11 PDP-controlled states at the time, challenging President Tinubu's declaration of emergency rule in Rivers State. But today, many of those states, as you know, have since shifted political alignment, raising fresh questions about law, about politics, and consistency. To help us unpack this on the show today, I'm joined by a lawyer and constitutional analyst, Libros Oshoma. Mr. Oshoma, thank you for joining us on Beyond the Headlines again. I'd like us to begin with the court's very first major finding. You had the justice saying that the plaintiffs failed to establish any course of action, excuse me, capable of activating the Supreme Court's original jurisdiction. And on that basis, he struck out the suit. Break that down for us. What exactly did these states fail to do in this regard?
Yeah, you see, some of us as observers had observed also when that suit was filed that would be the first hurdle that the PDP governors would have to cross, because the issue of local standing had always been, a germane issue in most of public interest matters such as that. You remember the two previous cases that had gone to court, they also were defeated on the grounds of course of action, right of action. And public interest matters are usually, determined, one way or the other in such ways. So in this case, what the court is simply saying is, look, you have not established, your rights that had been or would be violated by this action that was taken. And so to that extent, it becomes premature for you now to say that your rights, has been violated, that you need a court protection on same. So you remember the one that had gone to court before, the Plateau's governor's case, when the state of emergency was declared in Plateau. What happened was the Attorney General, who also was suspended alongside the executive members that were suspended, approached the Supreme Court. And the court said, no, you cannot. There was a preliminary objection. And the court also ruled that the Attorney General, having been suspended from office, certainly he lacks the locus to come to court, to approach the court as an Attorney General of the Federation. So also, but the difference in that one was that the court, didn't go further beyond that. They didn't rule either way. But this case now, because of practice direction, in some cases, before now, if this matter were to be an appeal, the matter is appealed, and then the court will take the issue of jurisdiction or the issue of local standard and then now remit. If it is determined that the parties has, the right of action, then they can remit the matter back to the trial court, to conclude whatever business they had done. But in this case, because of amendment in the practice direction, the law now permits a higher court to determine the preliminary issues. After determining the preliminary issues, even if they rule against you, they still go ahead to determine the substantive case one way or the other because it is a point of law. So that is what the Supreme Court had done in this case.
And that's very, very interesting, Mr. Shuma, because after striking out the suit for want of jurisdiction, this court still went ahead to consider the substantive issues and dismiss the case on the merits. I think that you already threw light to that because that's where many Nigerians may be confused. You know, that is that standard judicial practice, or was the Apex Court deliberately seeking to give some form of finality to this constitutional question?
No, it is now a standard judicial practice that when instead of unnecessary delay, that when such matter comes up, even if the court decides the preliminary motions or applications, the court can still go ahead to decide, even though they had ruled against you or the fact that you have no locus. But since it's a matter of law, the court, by practice direction, is still allowed to go into the substantive matter and rule one way or the other. And so that's basically what they have done. And they are completely in order. If previous Supreme Court had, similar latitude, we probably wouldn't have been here today. So the issue of whether the president had the powers or not will not be here. Even though I disagree with the judgment of the Supreme Court, I vehemently disagree with it. But even though others had,
it has happened again, Mr. Shuma. I remember that your light went off in previous interviews. But if you can still hear me, we can cover your image for a minute and continue this conversation. Are you still there, Mr. Shuma?
Yes, we can do that so that I quickly put on the gen.
All right. So you know that Justice Idris held that Section 305 empowers the president to deploy extraordinary measures, and that the Constitution does not really specify what those measures are. Does this judgment effectively expand presidential powers in that regard, or merely clarify powers that were already implied but contested?
What has happened here is that the judgment, I believe, expanded presidential powers because also if you look at section 188 of the Constitution on how a governor can be removed from office, it did not state in that section that subject to section 305 of the Constitution. It didn't state there that subject to section 305 and that which states that a governor can be removed by virtue of a declaration of a state of emergency because the powers are not explained. I think what the court basically had done is to extend the powers of the president to in a democratic dispensation. And if those powers, the fear is that if those powers falls into the hands of a dictator, then what we are seeing today might not be palatable because it's still stated. If you look at, if you go down to what do you call it, subsection, if you look at the law and you look at the provisions of section 305 clearly, and then you look at subsection 5 of section 305, it clearly states that if you permit me to read, because I've always stated this consistently, subsection 4, that the governor of a state may, within the sanction of a resolution supported by a two-thirds majority of the House of Assembly, request the president to issue a proclamation of a state of emergency in the state where there is in existence within the state any of the situations specified in subsection 3, C, D, and E of this section. And such situation does not extend beyond the boundaries of the state. So in this case, are we saying that the governor will invite the president to use extraordinary measures to remove him from office? That's the big question that the court also probably will never answer.
You know that.
So because
Yes.
Because if you look at all of that, the emergency situations, emergency in some cases, even though we agree, it might not be all of the states. So because the court has said that the Constitution did not state clearly, the extraordinary measure that can be used. So if there is an emergency, for example, in Koshofe local government, does that mean there is an emergency in the entire state? And if these powers falls in the hands of a dictator, the dictator can decide to say, you know what, there is emergency. And the Constitution says extraordinary measures. And the Supreme Court has said that since extraordinary measures is not clearly defined, and I can do and undo. And so I hereby declare state of emergency in the entire state and suspend all of the democratic structures in that state. So
I understand that.
That's why powers that are not contemplated within the democratic space.
I understand that the most controversial part of this ruling is the court's affirmation that elected officials may be suspended during a state of emergency, even though it also stated that it has to be temporarily. From a constitutional perspective, I'm sure in the coming days we're going to have conversations like, does suspension amount to removal by another name, or is the distinction legally sound? But I want us to look at the dissenting voice, because it was 6-1. Justice Obande Ogwanya dissented sharply, and for him, he insisted that while emergency powers exist, they shouldn't override democratic mandates. How significant is this dissent, and could it shape future constitutional challenges or reforms despite being in minority?
You remember in 1979, the celebrated case of Shagari and Awolowo, where the majority judgment ruled in favor of 12-3. And the minority judgment was that clearly there was no clear winner in that election. So one would have expected, and subsequently, the minority judgment later became the majority judgment when the same Supreme Court heard that majority judgment was given in error. So certainly, this, even though you would say that the minority judgment today is the popular judgment, depending on the side you're looking at it from, it will certainly in future shape, a legal discourse and seminars and symposium. And then also it would open a door of a request for an amendment to that section of the Constitution to clearly define these extraordinary measures so that you don't leave it in abeyance. So, because today it is Tinubu, tomorrow it might be something else, it might be somebody else. And who knows, like they say, you might have a Pharaoh that does not know Joseph. And he will say, well, when it was Tinubu's time, it happened and the court said extraordinary measures. So it will also shape further debate for a constitutional amendment to spell out the extraordinary measures. Just like the Supreme Court had said in Amechi and Omeha's case, that the courts, that the mandate belongs to the party. And that once the candidate is a candidate of the party, if the party wins an election, then the candidate automatically, once it was wrongfully suspended from the after winning the primaries, was wrongfully, substituted. Then, even if the party wins the election, it becomes the the beneficiary of such election. The National Assembly subsequently amended the Electoral Act to say if you did not participate, despite this judgment, if you did not participate in the entire process, you cannot reap the benefit of an election. So in the same vein, since we have discovered that there is a lacuna according to the Supreme Court today, that there is a lacuna that the definition of extraordinary measures is not stated. And so, since there is no definition, it can mean that a democratically elected government can be sacked just by fiat. Even though a community reading of the Constitution did not state so, that would mean that certainly, by virtue of that dissenting judgment, certainly we might need to begin to look for an amendment. But can this National Assembly amend the Constitution that way? That is a topic for another discussion.
We'll discuss if, as we speak, we have in our laws some guardrails that can check the excesses of a future dictator, as you have put it. But let's do that after this break. Stay with us, everyone. Broso Shoma joins me to discuss the Supreme Court position on the state of emergency as declared by President Tinubu in Rivers State. Thank you for staying the course on the program today. This judgment, as you have said, will almost certainly be cited in future emergencies. But precisely what precedent has the Supreme Court now set for future presidents? And just in case we have someone who fits your description of dictatorship, do we have sufficient legal checks to prevent abuse of emergency powers as our law is currently constituted?
I don't think we have enough checks now as presently constituted because the law is what the court says it is. And before now, why the debate was heightened was the fact that other matters that had gone to court, the one for Plateau, the one for Ekiti, and then subsequently, the fact that the former President Jonathan had an Attorney General who also interpreted the position of the law to say, no, Mr. President, even when you declare state of emergency, you have no power to suspend democratically elected, institutions. During the state of emergency declaration in Yobe, Adamawa, and Borno. So when it happened in Rivers, there was debate. So now the Supreme Court it's like the Supreme Court had made a law. That's why I started by saying the law is what the court says it is. The Supreme Court has made a law to give the president unfettered power by saying that extraordinary measures is nowhere defined. And so what that means is that extraordinary measures can only be defined by the president. The Supreme Court did not give us what will amount to extraordinary measures. So that would have acted as a check. But like I said, my fear, like I consistently say, is let it not fall into a hand of somebody who does not mean well. So that there are no checks unless we amend the Constitution to create those checks.
Perhaps we'll look to the National Assembly if there is the political will to make this happen in the short term. But, there's an interesting political development here. When you look at the plaintiffs then and now, the suit, as you know, was filed by attorneys general of 11 states, including Adamawa, Enugu, Osun, Oyo, Bauchi, Akwa Ibom, Plateau, Delta, Taraba, Zamfara, and I think there's Bayelsa somewhere there. All of them at the time, PDP controlled. Things have changed now. Today, many of them align with the APC, and it's raised questions about whether or not the case was more political than constitutional. Do you think that's a fair reading of this development?
Yeah, even though the case was anchored on constitutional provisions, but I think even the PDP governors that went to court, I think they went to court also out of political exigency. And that's why, if you remember, people were waiting. People had expected that the Supreme Court would determine the case one way or the other during the pendency of that emergency declaration. But what happened? People felt that the Supreme Court will house the matter. But we all know that if you file a matter and you need accelerated hearing, there are processes. You depose to affidavit of urgency, and then ensure that the matter is fast-tracked so that the Supreme Court can hear it expeditiously. But the fact that the governors did not push that also, introduced some element of politics into it. And then before you know it, you saw all of them jumping ship into the ruling party. But I must say this, that the fact that governors are in the same party with the president does not mean that they should always agree with him when it comes to the provisions of the law, always. And that's where we saw some governors of the APC during the 2015, 23 general election, approaching the Supreme Court to say that the president had introduced, a new currency. The currency, they redesigned the currency. And that by virtue of the provisions of the CBN Act, for currency to be redesigned, there's certainly the Federal Executive Council, apart from the Federal Executive Council meeting, the, is it the National Executive Council or Federal Executive Council? I can't really remember, must approve, and that they were not in such meetings, and there was never such a meeting. And so it was on that ground. These were the same governors on the same platform with the then president. So the fact that you are in the same party with the president does not mean that you agree with him constitutionally.
Depending on the political
I didn't
interest
see
at
that
the time.
push. Yeah, but I didn't see that push from the governor. So I will look at it more from, a political exigency because of fear that if we allow this to happen, then certainly we are also not, our foothold in our state will not be too firm. So
I hear you, Mr.
anything
Shuma.
can happen, and the governor can just say, the president can just say, well, I declare state of emergency in your state. So it was more political, to answer your question directly.
We have to leave in a few minutes, but I want us to turn to Rivers State shortly if we can, the trigger for this legal battle. With the benefit of hindsight, would you say that the declaration of the state of emergency actually de-escalated tensions and indeed restore order in Rivers? Because the way it appears now is looking like what we are experiencing is just a simple pause in what seems a deeper political crisis, if you are paying keen attention to what's coming from the House of Assembly and even Mr. Governor himself.
Yeah, if you take anything that the governor of Similari Fubara, said, if we are to reckon with it, it was like they needed that interregnum to de-escalate, even though a lot of us, I for one, does not agree with the provisions or to the position, the suspension of a democratically elected government. But the governor believes, even while he was decamping to APC, said that was what actually saved him. So the governor believes, and that because we might not know the underbelly of the activities that had happened, that transpired. So it is believed by the governor and some people that action by the president actually de-escalated. And now that same governor is in the same party with Mr. President and singing new songs. So who knows? If the state of emergency had not been declared, it probably would have been, gone by now. Maybe there'll be a kangaroo impeachment process, and the normal traditional.
But do you think that problem has been completely solved? Reading what has happened in the past few days.
Yes, I think the problem had been solved. Now, before, they were in the opposition party, and some people were of the view that the president has no business meddling in the affairs of the opposition party.
All right.
But the governor, only God knows the agreement that the governors have with the president, the way they are swamping into the president's party like bees. So now you have Fubara and then the House of Assembly members. So certainly,
right,
our political parties will tell you it's a family affair. Certainly, anything that is to happen. The man went to visit the president before he was received in APC, and the president detailed his minister for aviation to go receive him.
All right.
So anything that will happen now will be resolved in the hallowed chambers of the Aso Rock, and
good place to leave it. I guess we'll see how it all plays out in the coming days. Lawyer and constitutional analyst Liberals Oshoma, thank you so much for talking to us.
My pleasure always.
That's our show today, everyone.